Good evening. My name is Adrienne Ciccone, and I've had the privilege and honor to serve as the co-chair and co-founder of CLA's Racial Justice Committee, alongside the illustrious CLA President, Terrence Evans. The Racial Justice Committee was founded in 2020 in response to the killing of George Floyd. We provide educational programs, advocacy, and tools to foster racial equity. This evening, I welcome you all to this relevant and necessary panel discussion, Responses to ICE Actions. This evening, you will learn about the current litigation, frontline advocacy groups, and how you can help those facing ICE encounters. A huge, sincere thank you to all of our partnering bar associations, CLA Litigation Section, East Bay La Raza Lawyers Association, California La Raza Lawyers Association, Hispanic National Bar Association, and the Latina Lawyers Bar Association, and all of our fabulous planning committee members. I'm thrilled to introduce our powerhouse panel this evening. Our panelists are Yolanda Martin, the founder of the law office of Yolanda Martin, where she practices immigration law. Ms. Martin represents children seeking special immigrant juvenile findings in family and probate court. Prior to opening her firm, Ms. Martin was the managing attorney for CHIRLA's Removal Defense Unit, where she represented detained and non-detained individuals before immigration court. Welcome, Ms. Martin. Gina Amato Law, she-AYA, is the directing attorney of Public Counsel's Immigrants' Rights Project. She leads a 30-member team of attorneys, paralegals, administrative staff, and social workers who serve asylum seekers, immigrants in detention, survivors of violent crime, unaccompanied children, and victims of notario fraud. Her team works toward a world where all immigrants live with dignity, power, and opportunity. Welcome. Autumn Gonzalez is a labor and employment attorney. She volunteers with NorCal Resist, a grassroots immigrants' rights group, as well as the Center for Workers' Rights, and is a board member of the ACLU of Northern California. Welcome. Christina Ontiveros has worked at Kids in Need of Defense, aka KIND, since 2019. In 2023, Ms. Ontiveros became a senior attorney for the detained program of KIND Los Angeles. She has represented clients before the EOIR and USCIS in their adjustment of status, special immigrant juvenile status, asylum cases, and other matters. Welcome. Kel White is the Associate Program Director for Public Education and Training at Acacia Center for Justice. Prior to this, she worked at Amica Center for 10 years, working with people impacted by detention, supporting universal representation and due process for immigrants and removal with mental health challenges. She tracks patterns across the United States to see where advocates can join together to safeguard the rights of impacted people. Welcome. This panel will be moderated by Racial Justice Committee member J. David Sackman of RAC Law in Glendale, California, where he fights for justice daily and authors really interesting publications. And Brian Amaya, the Vice President of East Bay La Raza Lawyers Association and of the offices of Melanie Abea in the Bay Area, where he always works to increase the number of Latinx attorneys and judges in California. Special thank you and shout out to CLA and our committee manager, Brianna Hollingsworth, for managing this event. Next, I will turn this over to Jose Cordova. Jose Cordova is the chair of the litigation section of CLA. Jose is the first Latinx chair of the CLA litigation section. This moment in time is not lost on me. Jose?
Thank you, Adrienne. I think you stole a little bit of my thunder. I was going to say that, but good evening, everybody. My name is Jose Cordova. I am the chair of the CLA's litigation section. And as Adrienne mentioned, I am the first Latino to become chair of the litigation section in all of its history. On behalf of the section, I welcome you all to tonight's program. Briefly, I'd like to add that I grew up in the southern San Joaquin Valley. I was born in California, raised So I deeply feel what's happening to the immigrant community because I've been around them my whole life. So I'm really looking forward to this program.
Alex?
Good evening. My name is Alex Hernandez, and I am the honor of being the current president of the East Bay La Raza Lawyers Association. Our association is made up of lawyers from Alameda and Contra Costa counties in the Bay Area who aim to uplift our community in the legal profession. First and foremost, on behalf of East Bay La Raza, I want to share our appreciation and gratitude to the presenters here today, not just for agreeing to present, but also for being on the front lines and fighting each and every day in a very important battle. On behalf of East Bay La Raza, I would like to thank CLA and all of our partnering organizations for coming together to organize and present this great educational opportunity. And I'd like to thank all of you and welcome you all for being here in this important series and webinar. I too have I'm an immigrant from Colombia, so this subject matter is very important to me. And I also want to extend, if anyone is interested in joining our association as a member or interested in working together on any issues or simply getting together for community and camaraderie, please don't hesitate to reach out. Thank you all.
Thank you. Maria?
Good evening, everyone, and thank you for joining us here today. My name is Maria Mota, and I am on the board of the Latina Lawyers Bar Association, a co-sponsor for tonight's webinar. LLBA is a nationwide organization, and our mission is to increase the 3% of Latinas in the legal profession by providing scholarships, bar stipends, mentorship, and community. We encourage you to connect with us on our website, Instagram, Facebook, or LinkedIn, and become a member. I would like to thank CLA Racial Justice Committee for putting this webinar together, and East Bay La Raza Lawyers Association, California La Raza, and Hispanic National Bar Association for co-sponsoring. Thank you.
Thank you so much. David Casarrubias Gonzalez.
Hi, everyone. My name is David Casarrubias Gonzalez. I'm the regional governor for the Hispanic National Bar in Northern California, and my region covers all of Northern California and the state of Hawaii. The HNBA's vision statement is to serve the interests of the Hispanic legal community and to advance the representation and influence of Hispanic lawyers, judges, legal professionals, academics, and law students, and to advocate on issues affecting the broader Hispanic community, one of which is immigration. I'm really looking forward to tonight's panel, and I thank all of the panelists for sharing their wisdom with all of us tonight.
Thank you. And last but not least, Maria Dominguez.
Hi, good evening. Buenas tardes, buenas noches. I'm Maria Dominguez. I'm the immediate past president of the California La Raza Lawyers Association and also the immediate past president of the East Bay La Raza Lawyers Association representing Alameda County and Contra Costa County.
Okay, now, Maria, would you like to provide your overview?
So this evening, I have the distinct privilege of providing a brief history of U.S. immigration enforcement. And I'm going to do so in a very as far as the undercurrents of immigration enforcement in our country. So I do have some slides to share. So I am going to attempt to do that with hiding the presenter view. So give me just a few seconds here. All right. And if somebody could let me know if you could see my slides.
Yep, I see it.
Okay, great. So again, this is very abbreviated. So before 1876, most of us know that white European settlers occupied what's now known to be the United States, the land of indigenous people. And at that time, before 1876, it was the individual states that largely handled immigration issues. So fast forward to what happened after 1876. In 1876, there was a Supreme Court case, Chai Lung versus Freeman, and that established for the first time the federal authority over immigration and foreign relations. Up until that time, it had been handled by individual states. And of note, it has been cited as recently as 2012, relating to the government authority on matters relating to immigration policy and immigration enforcement. The late 19th century, and I'm highlighting some key legislation and key cases. So in 1882, hopefully have heard of the Chinese Exclusion Act, which prohibited all immigration from people of Chinese ancestry and specifically Chinese laborers for 10 years. Throughout the history of immigration legislation and policy, a common theme is the racialization of the policies. And while there could be some arguments made that policies have been race neutral or have not been or have been targeted to specific nationalities, perhaps, or heritage, the case can be made that the national origin has been used as a proxy for race. In 1891, the Immigration Act created the Bureau of Immigration in the Treasury Department. So it was the first time that we had an actual department of government, marking the formal start of federal oversight and inspection. Fast forward to the earliest 20th century. In 1903, there was an Immigration Act that added, quote, anarchists and subversives to the exclusion list. So we started seeing here, additional exclusions based on behavior and conduct. In 1917, that year's Immigration Act introduced literacy tests. And, given that, today, we are talking about race, we have seen a history of how literacy tests have been used to keep people from voting, for example, throughout the history of the United States. So it's really interesting to see how literacy tests also have come in to play in immigration policy. The 1924 Immigration Act set strict national origin quotas, drastically reducing immigration, particularly from Asia. And we still see remnants of that today. If you take a deeper dive into immigration policy, you will see that quotas are still in use, and they disproportionately affect many people from the global South and from whomever the current administration may seem as undesirable or undesirable. In 1924 marked the creation of the Border Patrol, and they were formed to secure the borders. That's a whole topic in of itself, the history of the Border Patrol, but I do want to make a point that a lot of the history of the Border Patrol is rooted in the history of the policing of people of color, including the role of the Texas Rangers, for example, that also have a history of policing people of African descent and people who have been enslaved. In 1933 marked the creation of the Immigration and Naturalization Service, INS. Some of you may have heard what was a precursor to what is now USCIS. Well, INS consolidated the immigration and naturalization functions and moved the department under the Department of Justice in 1940. Again, another fast forward in 1986, the Immigration Reform and Control Act, also known as IRCA, marked the modern enforcement era, and it made it illegal to hire unauthorized workers and increase border enforcement while granting amnesty to more than 3 million immigrants. This is the last comprehensive immigration reform that has occurred. And I do want to note that, my parents immigrated from Mexico and El Salvador, and they immigrated in the 70s. But I know that so many of our family and friends were beneficiaries of this IRCA reform and have had lasting effect on the ability to have a lot more opportunities than other immigrants who have not had the benefit of any comprehensive immigration reform since then. IRCA introduced penalties for employers who, knowingly hired undocumented workers, and it also established a legalization process for agricultural workers. In 2002, there was a major restructuring in the wake of September 11th, 2001. And as you may be familiar with the Homeland Security Act of 2002, that dissolved the INS, and it split the duties into 3 different agencies, all under the umbrella of the Department of Homeland Security in 2003. So now we have what is now called the U.S. Citizenship and Immigration Services, the USCIS, and that is to handle applications and benefits, while the U.S. Immigration and Customs Enforcement, ICE, it was created to manage the interior enforcement. So, not at the border. And then U.S. Customs and Border Patrol, CBP, was to manage the border inspections and patrol, keeping the role of what was, already there at the time, the Border Patrol. From the 2010s to the present, we have seen an increased reliance on quote unquote expedited removal processes, with deportations exceeding 400,000 in 2013 under President Obama. And ICE now has more than 20,000 law enforcement and support personnel in more than 400 offices in the US and around the world. And this number keeps growing and growing, given that Congress has been allocating more funding to this apparatus, and including, as recently as this week, we see that this is being taken up by the current Congress. There's 3 operational directorates, and some of these you may or may not hear this evening. There's the Homeland Security Investigations, HSI, the Enforcement and Removal Operations, ERO, and the Office of the Principal Legal Advisor, OPLA, and then a 4th directorate, the Management Administration, which supports the 3 operational branches. So in summary, it's a very large bureaucracy that's growing, has many arms, many tentacles. But again, some of the common themes are how race has been used throughout history to legislate and to target, certain groups of people, and also how enforcement keeps growing and increasingly becoming, seen and recognized as a police state, as an apparatus that engages in policing practices where there's a lot of criminalization and criminality. I've also seen why there has been the growth of the practice of crimmigration, which looks at the intersection of immigration and criminal law. And this evening's panelists, I'm sure, will touch on some of those things. So that is my very short presentation. And now I will turn it back to, I think, our moderators, Brian and David.
Good evening. Can everyone hear me? Okay. I'm J. David Sackman, and I'd like to say this subject is very personal and deep for me. I started my legal career a long time ago in the beginning of the Reagan administration, representing people in detention in the El Centro Detention Center in the Imperial Valley. Most of them were Central American refugees. I would often have to ask them for their asylum application about their experiences and why they're applying for asylum. Often they would respond with a vacant look. Their eyes went hollow. They went off to a place of horror that I could not even imagine. I've seen that look before. My own family, nearly every single one in Europe, was murdered in the Holocaust. The one survivor of the death camp I was able to talk to, I asked him about his experience, and I saw that same look. So there's a direct line here, and I think it's important, as Maria pointed out, to know the history. And part of it is that there was no control of the border at all for the first century of this country. And the first law was explicitly racist, excluding the race of Chinese. And pretty much every law since then has either been explicitly racist or motivated by race. Now, I didn't last too long in immigration. It is very difficult. I called it doing criminal law without the Constitution. But there are some very brave people here today, dedicated people who are continuing that work, that important work, against all the odds and even worse conditions than what I face. So the first one, who's our first speaker, is Yolanda Martin, who, as you heard, runs the office of Yolanda Martin, where she's on the ground doing immigration law, especially for children who are especially vulnerable. And she's going to talk about the actual process, not just, the law, but the actual process of what is happening in immigration proceedings. So take it away, Yolanda.
Hi, good evening, everyone. Again, my name is Yolanda Martin. I've been doing immigration law I did the math earlier today, over 12 years. And so from the beginning, I've been doing detained and non-detained work and representing children. So we've gone through a lot. It's been a roller coaster, and even within each administration, also a roller coaster. But I'm going to touch upon a little bit, and I could speak forever, so please let me know if I'm going over time. But I do want to talk about a little bit about what happens when a family member is detained. So, for example, and I would suggest everyone, if you have someone you know that does not have legal status or has questions about their legal status, just from the get-go, already go see an immigration attorney or one of the nonprofit organizations that provide consultations, because you don't want to be left at the last minute not knowing what your family member status is. I've had clients come to me with the family doesn't even know that they had a work permit or that they had a previous deportation order. And knowing, especially if they've had a previous removal order, it's going to be very important to know how quickly you have to move. Okay. And so whether the attorney you're going to reach out to is able to take on the case or not, because there's different strategies that might be needed, especially if there is a removal order. So, for example, here in LA, LA County, majority of the detainees are being taken to the federal building, which is at 300 North LA, right by the Placita Olvera. So that's one of their processing centers. We usually get calls from family members that their family member has been detained. And as attorneys, as legal representatives, we are able to go see the detainee. There have been issues, especially last year, on being able to go see the detainees, whether we would be allowed to go in. But at the moment, I think we are in a better position when it comes to that. So an attorney can always go see the detainee there. And what we do is make sure we give a bit of advices to the detainee, because oftentimes people they will be threatened or intimidated, I guess could be the word, on whether they need to sign something in order to be released, and at times they don't know what they are signing, right? And feeling that pressure, like, it's horrible. So we make sure to go and see the detainees, talk to them, see what type of relief they might be eligible for, just so that we can know what the game plan. But even before that, I know we have some resources that were provided, that will be provided, I believe, where it has information of what a family member what type of information they can already have, so that when you go to the attorney, they can have a better idea on how to help your family member. So, for example, here at the federal building, in previous years, we would be able to speak with an ICE officer and see whether they can issue an ICE bond or be able to release the detainee right from the federal building. However, now that's not happening. So, oftentimes when someone is detained, there's something called an ICE detainee locator. You could Google it, ICE detainee locator, and you can use that to find the detainee. You oftentimes would need, for example, the name and the date of birth and country and nationality. But it's really important I just want to make sure that you all know that sometimes people's names don't come up, they don't come up in the system right away. It could take up to 24 hours as well. So I would encourage if anyone's detained that they know that they should request the opportunity to to make a phone call. And so make a phone call to someone who is a trustworthy person that will reach out to an attorney. But yeah, so we have that, and we also so from when someone's detained, they can be taken to different detention facilities. For example, we have Adelanto here, like about an hour and a half. We have Mesa Verde and California City, which is the new one. Um, and once we are able to find out where our family member is, where our detainee is, what we do is also we're able to request for bond, right? And the bond is one of those things that has been like a roller coaster for us as well. Because generally, and I still remember this because I had a hearing on July 7th. And so the day after July 7th, the judges started saying, we don't have the immigration judges started saying, we don't have jurisdiction to be able to issue a bond or to hear a bond hearing for your client, when that had not been the case before. Okay, unless you were something called mandatory detainee for certain types of crimes or maybe for other reasons, but usually you would be able to request a bond. And so that changed July of last year. And then the only way that and then we later on we got some case law saying, formalizing it. And I believe one of the other speakers is also going to speak about habeas petitions. And so far, until recently, that's the only way we've been able to have people released from detention. So organizations like USC have been helping with the habeas petitions, and other private attorneys as well. So if you're able to do that, that is another way that you can help. More recently, there has been a new order, kind of sending it back to the way it was before. So we're hoping to be able to get more detainees out without that hurdle of a habeas petition. And I think there was a question. Yes. So, for example, if someone is taken to B18, which is the processing center here in LA, they should be able to get a visit from a family member, U.S. citizen. Of course, make sure to check that as well. But generally, it will be the legal counsel that will go see them. Um, so yeah, so right now I also want to make sure that people know that with regards to bond, we show flight risk and danger to the community. It's really, really important now that some judges are and government counsel are finding any little thing to be a flight risk. So if you, for example, you were in a car and the driver, drove away from officers, even though you were a passenger, they're trying to say that you ran away, that you did this. If you were startled, for example, when the officers came and your flight and fight, feeling, they're trying to point that out as being a flight risk for immigration purposes. So, take that in mind. And one of the other things I just wanted to point out, last thing, is that there are bond funds and immigration bonds are you have to pay the full amount. So for example, right now, no crimes, $10,000, and the family has to pay the full amount. So another way to help is donating to bond funds. Thank you.
Thank you. I just wanted to point out, let me see if I can share this. There's some materials that should be, I don't know if it's been circulated yet, that can be very helpful here. One is a community resource guide that has first steps, and it has the link that Yolanda mentioned here to locate people for whatever it's worth. Another important thing is the Neighborhood Legal Services here in LA made this family preparedness guide, and this is really useful before you get to Yolanda to have this filled out before anything happens. So be sure to download that. I have a few questions, but first, I don't know if you answered this. There's one question is whether any attorney can visit a detainee. And I mean, that's a problem I had when I was representing people. We referred to go into there, but they couldn't sign. There's a document you sign to be representing people, right? I think it's a
So,
G28 form. So how do you get in to see someone before to get them to sign that?
so now there's a virtual system that you can file a G28 as well without having the detainee signature. And so that's been great as well. And so I take a copy of that. If I already filed it, I take a copy of that and I take a blank copy so I can have the detainee sign it once I'm there as well. So that's how I've been able to do it.
Okay, well that's an improvement. That's good.
Yeah.
Um, One of the things, that I hear constantly from people is, oh, why can't they just do it legally? Why do they have to come here illegally? Why can't they? And I guess they think they just have to fill out some forms and pay a fee and then you can immigrate. Is it really that simple?
No, I mean, there's only specific categories can immigrate to the United States. And even for some categories, there are limitations, for example, between siblings that take many, many years to be able to come to the US. And even once, let's say you're here, you entered the US, having a US citizen child is not enough usually not enough to be able to adjust your status. And this is a frequent thing that we see. People are lied to and told, oh, you have a US citizen. They can petition for you. Yes, they can petition for you once they turn 21 because you're only showing the relationship. But a lot of people need something called a provisional waiver for being here unlawfully. And unfortunately for that, to qualify for that, you need to have a US citizen or a legal permanent resident wife or husband or parents. And oftentimes people don't have that. And so that's difficult. And one other thing is that, departures from the US, after being here for a certain amount of time, they do have consequences. And then returning again without authorization, those have very big consequences that not everyone is made aware of when they apply for relief.
So what if you do have legal status or even a lawful permanent resident, a so-called green card holder? Can you still be deported?
Yes, unfortunately, you can. I've had many cases like this. There are crimes that make you deportable, okay? And having these type of crimes will, for example, will cause you to possibly get something called a notice to appear, which is when immigration is it's kind of like the equivalent of criminal charges, but in immigration. So it's a way to start a case, immigration case against the person for their removal. Um, there is an application to try to be able, it's called cancellation of removal for permanent residents, to try to be able to keep your residency card. But it does have several requirements. It cannot be an aggravated felony, for example, and it requires you to have been a resident for a certain amount of time. So that's something that is, crucial to look at. And one other thing I would mention about this is that once if you have one of these crimes, when you depart the United States and you try to come back in, you very likely will have an issue with immigration and you might be put into immigration proceedings. So yeah, please be very mindful of that situation.
Well, following up on that for the attorneys out there in criminal law, what can criminal defense attorney and prosecutors too, actually, what should they be doing in regards to immigration for people in criminal proceedings?
So as to criminal attorneys, I would say make sure that your client is aware that, whatever plea they're going to take and for whatever crime it could affect their immigration proceedings. And that they need to reach out to an immigration attorney or someone who is knowledgeable and is able to provide them a real assessment. And for example, the public defender's office has an immigration unit. There are plenty of trustworthy attorneys here in the LA area in California that are able to provide those immigration consequences. For example, letters that can be criminal attorney could speak with the prosecutor to be mindful.
And if they don't do that, is there a consequence? Is there a statute that covers that?
Yeah,
Martin,
so
Ms. Martin, if I can, we need to move on to the next person. So thank you. Can you hold that? And
yeah.
David, can you get to Ms. Amato from Public Counsel so we can keep time? Thank you
Okay,
all.
we should put it up. The code section is Penal Code Section 1016. So Yolanda gave us a great view of what it's like on the ground in immigration proceedings. The in in the trenches, so to speak. So we're going to move on to Gina Amato, who, as you know, was introduced, is with Public Counsel. They're one of the groups that are doing great work in impact litigation in this area. And a lot of the cases you're hearing about comes from them. Gina's the head of the immigration, the director of the immigration section. And so she's the one behind a lot of these impact cases. And this thing's happening every day. I think you just look in the daily reports every day. There's something happening. I think they had oral argument in one of them the other day, and decision just came out today in another one. So I'll just turn it over to you, Gina, to start talking about these cases.
Great. Thank you so much. Affirming you can hear me through these headphones, right? Okay, awesome. Very nice to be with you all. Thank you so much for having me. I'm going to bring up some slides, and I know I have 5 minutes to, sorry, let me move these so I can start the slideshow. So I just want to give you a brief introduction to the work that we're doing at Public Counsel in response to the current ICE enforcement era, and then answer any questions that you all might have. Again, a real pleasure to be here with you and with some real veterans in our field like Yolanda Martin. Nice to see you, Yolanda. Very quickly, let me just skip over this. So Public Counsel is a nonprofit law firm in Los Angeles. We're in the Koreatown neighborhood of LA. We provide free legal services in a lot of different areas. We have 7 different projects, about 175 staff members. And our Immigrants' Rights Project is our largest project. Let's see, our largest project of 7. So our Immigrants' Rights Project, this is I would say most members of the team. We're a 30-person interdisciplinary team of attorneys, social workers, and admin staff. Our mission is to collaborate with underserved immigrant communities to fight fearlessly for humanitarian protections and a just immigration system. And we do that through a really multifaceted approach. So our bread and butter is really providing direct legal services to underserved immigrant communities, much like the work that Yolanda was talking about, assisting, working directly with impacted communities and assisting them in applying for lawful status in the United States. So the communities that we focus on serving are unaccompanied children, which are children who entered the country alone without their parents or legal guardian. We have a survivor team that focuses on serving immigrants who have been victims of serious crime or human trafficking. We have a pro bono asylum team that really tries to mobilize the private bar to serve people who are seeking asylum because they have either been persecuted in their home country or fear persecution upon return. We have an anti-detention team that engages in detention work, so working with immigrants who are detained in the immigrant detention system, representing people who have cases in immigration court and are fighting their removal, as well as engaging in rapid response efforts to help those who have been caught up in the raids. In addition to this direct service work, we do policy advocacy and strategic litigation to advance the rights of the communities that we serve and protect their rights in court. And then we engage in a lot of community education as well as media efforts. These are our intake lines. Our 600 line is for English, 601 is for Spanish. So feel free to give us a call or to give our intake information to anybody who you think might need the services. So I wanted to spend a few moments on our strategic litigation. We have been providing direct legal services to these communities for over 50 years. I would say these efforts to engage in strategic litigation in a more organized and robust way is fairly new for us. I was able to create this team, the Policy and Strategic Litigation team, in this past year, and we launched these 4 efforts, very much in collaboration with a lot of different community partners. So our first was Vasquez Perdomo versus Noam, and this case arose directly out of the raids that have been happening in Los Angeles since early June.
What we saw, which we all saw, across, and we have seen across the country, is ICE engaging in racial profiling and roving patrols and just picking people up indiscriminately, taking them down to the federal building and then denying them access to counsel. So we had attorneys on the ground in those early days, and that really gave rise to our partnership with many different organizations to launch and carry forth this piece of litigation. It has been, there are always hills, peaks and valleys. We're continuing to litigate the case. I can provide updates, but essentially what we're trying to do is stop these raids and stop the use of racial profiling by ICE. Our next case that we filed was ACR versus Noam, followed by ICWIC versus Noam. In both of these cases, challenged the rescission of protections for the first case is to protect unaccompanied children, and the second is immigrant survivors of serious crime and human trafficking. Traditionally, under prior administrations, these communities had certain legal protections that they could enjoy while they waited for the immigration process to play out. And these protections allowed them to work in the United States as well as avoid deportation. And we have seen the government rescind these protections and deport people who even have these forms of immigration relief already. So like the U visa, for example. So we're fighting to maintain those protections and make sure that unaccompanied children and that immigrants who have been victims of crime and trafficking are protected by our government and by our legal system. And then finally, our most recent case is LT versus ICE. And this case is to challenge really substandard conditions in the Adelanto Immigration Detention Center, which, as Ms. Martin said, is our closest detention center here. We have heard numerous reports from our work directly with the people impacted about medical neglect, about substandard food and water, about just lack of habitable conditions within the detention centers, overcrowding. We had 2 families at our recent press conference who lost loved ones who passed away in ICE detention without them ever knowing that their loved one was even sick and needed medical attention. So we are really proud of this work that we're doing. And I think it's important for me to say that while we are challenging the substandard conditions in the Immigration Detention Center, we are also working toward abolition of the entire Immigrant Detention Center as a whole. So I don't want that to be lost. It's not good enough to just try to improve the conditions in one detention center, because this entire system of incarcerating undocumented people, most of whom have had zero contact with the criminal justice system, we just believe is inhumane altogether. So we're working toward the abolition of the detention center system as well. And I think that was my last one. I hope I made my 5 minutes, and happy to answer any questions.
Okay, well, let me ask you about some of these cases. The Vasquez Perdomo, actually, you're going to have to change the name of those cases, aren't you? If you haven't heard, Christine Noam's been fired. I don't know if that'll change anything, but change the name. In the Vasquez Perdomo case about the racial profiling, where are we there?
Well, okay, so just a little recap, it's been already a sort of a complicated history, but we're litigating this case in federal court. The district court judge, Judge Frimpong, initially, yes, enacted temporary restraining orders, which the government challenged. It quickly went up to the Supreme Court. The Supreme Court overturned the restraining order, essentially saying that ICE could engage in racial profiling and that what they were doing, just grabbing people off the street, was in compliance with the law. We continue to gather a mountain of evidence showing that their tactics are motivated by racism. As Maria, actually, as we opened up this session, I think we very clearly see in the Vasquez Perdomo case this not only trend, but just this practice of using race as a proxy, and just the intentional and deliberate targeting of Latino communities in this enforcement operation. So So in Vasquez Perdomo, we just amended our complaint to include an equal protection claim, very clearly stating that the government's intention is to target Latino immigrants in particular. And we will continue fighting that case because the mountain of evidence is in our favor, the law is in our favor. It is clear that this administration is violating the constitutional rights of Latino immigrants and other immigrant communities, and we will continue fighting the case until we win.
Another case, I don't know if it was mentioned there, was the one where the U.S. is challenging California laws, the anti-mask law, the ID law, and I know that's pending, I believe, in the Ninth Circuit. But I have a more general question of whether state laws have been successful in protecting immigrant communities from federal enforcement.
Yeah, so in many instances it has. And so, for those who are not immigration attorneys, there's always a huge tension between federal immigration law and the right of the states to enact immigration legislation or any type of legislation that protects immigrants. Where I think that we have seen success is when the state enacts legislation that dictates the use of local resources. So, for example, SB 54, the California sanctuary law, that's one of the most, if not the most robust sanctuary law there is. And what that law says is that the state has the right to use its local resources on local issues, to use its police on local issues, and to not collaborate with federal immigration enforcement. And the 10th Amendment provides for that. The 10th Amendment of the Constitution provides that any power that is not explicitly reserved to the federal government or assigned to the federal government is reserved to the states. And so when the states have taken that stance and passed legislation focusing on the use of its resources for local issues, we have been successful.
Okay, well, thank you for your work. We have a lot more questions, but I think we're going to try to put those toward the end so we can all chime in.
Great.
So
thank you.
We'll move on to Brian, who's going to take up the next speakers.
Thank you so much, David. And thank you so much for everyone that's spoken and that will speak. This is amazing, and I'm really happy to be a part of this. Before I start asking or moving along, I do want to point out that I am also the child of two immigrants. Both my parents are Civil War refugees. And so this is important not only because we're talking about my cousins, we're talking about my family, we're talking about my grandparents, my partner's family, but also because this is not where it ends. If we don't stand here, it's going to keep going. And so what comes next? They undo my parents' citizens that they got a while ago because they weren't born here. And then what comes after that? They undo my citizenship because when I was born here, my parents weren't citizens. Like, this is where this is going. And so let's not pretend that this is where they're going to stop. And so we have to stop here. We have to stop now, because if not, it'll be too late. And with that, I want to, introduce Autumn Gonzalez, who's here from NorCal Resist. Really happy to have you here, Autumn.
Thank you so much, Brian. So, hi, everybody. My name is Autumn Gonzalez, and I'm a volunteer with one of the rapid response networks in our state, NorCal Resist. So hopefully the information I can provide will help those of you who are, like myself, not immigration attorneys, find a way to plug into the work, because everybody can do something right now. I know, like, a lot of us can't necessarily take on an immigration case, like that's not our wheelhouse, but there are other ways that you can plug in and support the important work that all of our immigration attorney colleagues are out there doing every day. So just really briefly, the way that rapid response networks work, and each network is a little bit different, but they train volunteers to go out into the community when ICE is spotted or potentially spotted somewhere, usually through a hotline. And folks go out and they observe and they record. And it's really important First Amendment work that these rapid responders are out there doing. It's also really scary and dangerous right now. I know in our rapid response network, our volunteers have been pepper sprayed by Border Patrol. They have been harassed by local police. They've been harassed by the FBI, and obviously harassed by DHS. So one way that attorneys can plug into this is, of course, becoming rapid responders, because who better to be out there using their First Amendment rights than people who are very well educated on how their First Amendment rights work and are able to stand their ground and record and get that documentation that the immigration lawyers or the other attorneys may need down the road. But it's also really helpful to reach out to your local rapid response network, and you can find a list of all of the networks in California on the website ccijustice.org. There's a directory there, and all the networks have like a website that you can get on their email list and get in contact. But we really need attorneys to provide know your rights trainings to our responders. So these are trainings that can be in English and in Spanish, and really teach regular community members about their rights to record the police, their rights under SB 54, what to do if, the police give them an order or DHS gives them an order, these kinds of things. What happens if you're arrested? These are like a lot of things that most everyday people just do not have a lot of experience with, whereas attorneys often have intimate experience with the criminal justice system and can really demystify it and help people feel more comfortable in navigating and using their rights. So that's really important work. There's also the know your rights components for our impacted communities. So the immigrant community themselves need these trainings in every language that you can think of. So if you have a second language or third language skill, whether it's Spanish, Russian, Dari, Punjabi, there is a huge need out there for people to go out and give very simple know your rights trainings to people. But as we've seen over the last year, people understanding the difference between an administrative warrant and a judicial warrant, people understanding their right to not have to open the door. These are really they're critical information that people can use to stay safe right now. So hearing that information from a trained attorney who, brings it out to the community, brings it to local churches, to local schools, to parents groups, it's super important right now. And it's a really easy way that attorneys can plug in, because it's like just giving up an hour or two of an evening or a weekend to go out and do these kinds of trainings. But beyond that, if you're someone who has more time and you're interested in digging in a little more, I think Kelly's going to talk about the habeas work that is out there. There's all these different programs being stood up, and habeas is really the only way that we're seeing people get out of immigration detention right now. So it's incredibly important, and it's a way that really any attorney who has some familiarity with litigation can plug in and get going on that. But even if you don't want to be the frontline person filing, there are all these needs for research, for actually going down to the federal court and just helping to print the paperwork out, all these different pieces of it that don't necessarily mean taking on a full case. There's just the research and other components of work that needs to get done, and it's not always glamorous, but it's stuff that you can do from home after work or whatever, and just help make a difference. I think that's probably everything I want to say right now. So definitely ccijustice.org to find your local rapid response network, and there is a huge need for your time. So
Adam, I had a question for you. There was something we talked offline about court watching. Can you talk a little bit more about what it is to court watch?
thank you. Yes. And Kel might also have a little bit to say about that, because we work really closely with the case Shaw and Court Watch. But as I'm sure everybody's seen in the media, ICE has been doing enforcement activities inside the immigration courts, which, obviously should be a safe place. We've been really lucky that there have been a lot of court cases and injunctions, and a lot of that has stopped, at least in Northern California. I saw some media that it was still happening in San Diego, so I know it's still a need. But there are just all kinds of really unacceptable behaviors happening in our immigration courts. Besides the fact that like a ton of our immigration judges have been terminated, the courts are kind of in chaos right now. And then people are feeling threatened and harassed by ICE in these actual buildings. So court watchers basically are there on the ground. They document, they watch what's going on, and then they're also looking for patterns in how DHS is behaving in court. So they have like a bird's eye view, and they can see when they're changing their tactics, what kind of motions are they bringing. And that's how we got this information on this relatively new thing they're doing, the pre-termits, where they're making these motions to basically force people back to other third countries where they have no ties. Just really, really ridiculous things happening in the courts, and having attorneys there who can kind of at least understand the jargon and what's happening makes it a lot easier for the immigration attorneys, who obviously can't be there all day, to get the information they need to start thinking about litigation and other strategies to shut some of this stuff down. So.
And when I visited the NorCal Resist website, I noticed that you guys do sort of a what do we call it? You guys fundraise for immigration bonds. Like, can you talk a little bit about that and how maybe how other places are also doing that, so that other people can join in that way, in a financial way?
For sure. I dropped a link in the Q&A to a list of all of the nationwide immigration bond funds. There are a few immigration bond funds down in Southern California, like the Orange County Justice Fund, that, are very localized, specific to an area. So definitely, we all know Southern California has been hit so hard. It's great to, host a fundraiser at your house, or, get your colleagues to chip in. NorCal Resist has a nationwide immigration bond fund. We posted over $1 million in bond last year, which sounds like a lot, but that freed less than 200 people, because these bonds, as folks were talking about, are just ridiculously high. Last week, we paid 3 bonds, $60,000. So it was one $25,000 bond, one like 20, and one 5. It's just totally out of reach for families. And if people don't post those bonds within a certain amount of time now with habeas, a lot of times the bond is lost. Like, they don't have the opportunity at all to get out. So definitely there's a range of bond funds around the country, around our state. They're all doing as much work as they can right now, but because we're having so much success in habeas, which is awesome, there is a huge need right now for just to get more money into the system to get more people out. So that's another great way to help.
Thank you so much, Autumn. I really appreciate that. We're going to move on to our next panelist, Christina Ontiveros, who's here from Kind.
Hello, everyone. Can you hear me?
Yes.
Great. Okay, so likewise, I'm going to see if I can share my PowerPoint without any issue. Give me 1 second. Okay, can you see my screen?
Yes, we can see it.
Okay, great. Now I just need to figure out how to look at my presenter view. Give me 1 second, everyone. Because I think if I exit, oop, no, if I exit, it stops sharing, correct?
Yes.
Is what I gather. Okay.
And while we wait, just a reminder that we will be sharing all the links and materials after the webinar. It may take us until tomorrow, so please bear with us.
Okay, let me share once more.
And I also want to make a comment that, throughout the presentation, you may hear the very deliberate choice that we use terminology like unauthorized or without inspection instead of the pejorative term illegal. As attorneys, especially, it's really important for us to think about, why we do have due process, and also the importance of not further dehumanizing people who, for whatever circumstance, may not have access to a quote unquote lawful status or authorized status. Thank you. Christina.
Yes, thank you. Okay, you can hear me and you can see the screen. Great. Okay, so Hi, as people have said, my name is Christina Ontiveros. I'm a senior attorney with Kids in Need of Defense. And as this webinar focuses on the impacts of ICE enforcement as well as responses to it, I thought that it would be a great opportunity for me to talk about who Kind is, who our clients are, and what Kind's role is in representation and advocacy. Oh, okay. So our mission in general is to be able to ensure that no child appears in immigration court alone. And we do that by not only doing direct representation work, but also ranging our capacity by including pro bono attorneys in our fight, in our in the good fight. As well as advancing policies and practices through advocacy up in the congressional areas of our country. And we also do work outside with international presence to help with reinforcing regional protections for children as they journey in their migration journey. And so, as it was mentioned, right, we throw about a bunch of terms that are very normal for us to use on the daily, but just for those who are unfamiliar, an unaccompanied minor is a child who is under 18, is without lawful status, and without a parent or legal guardian in the US. That's not available to take care of them. In other words, what this means is that the child entered the United States without a parent or legal guardian beside them to undergo the entire screening and processing as they start their immigration journey here in the US. And so unaccompanied children journey to the US due in part to serious safety concerns that exist in their home country, like the ones listed on this slide. They can vary from gang violence to abandonment to trafficking, or a mix of all of those combined. And so these journeys are not done at a whim. They are done very deliberately in order to be able to have a fighting chance at survival. And the journeys that unaccompanied children have are rarely direct. They either spend days or weeks or even months moving through multiple countries, often without stable shelter, reliable food, or a trusted adult who is accompanying them, which often exposes the children to further harm, such as exploitation or abuse. And so here's an overview of an unaccompanied minor's immigration process. So once a child makes it to the US, they're forced to navigate a very complicated immigration process from the outset without even having a chance to process what they have lived through in order to get here. Again, they don't have an adult figure by their side most of the time, and they definitely don't have a legal representative to help them comprehend what is being asked of them at the border. And so Kind, in an effort to kind of respond to the inherent complexities that exist in the immigration process, especially for children, created 4 programs that really are our core sort of frameworks on how we approach representation for unaccompanied children. And so the 4 programs are legal protection, psychosocial programs, global programs, and policy and advocacy. For purposes of this short presentation, I'm only going to focus on 3. Even though global programs is also important as well. But these programs together create a holistic representation that's focused on meeting our clients' needs to the fullest. And so, for instance, for legal protection, what Kind does is we provide, again, direct representation for children in immigration proceedings. And we also expand the capacity by recruiting, training, and mentoring pro bono attorneys throughout a case. We also do Know Your Rights presentations for both released and detained children. And this is so we are able to educate our clients and their communities on the processes involved in their immigration case, as well as the available protections. As this is a webinar on ICE enforcement, it's very important that children are aware that they have certain rights that no one else can take away. For example, the right to remain silent. In a fair amount of my cases, remaining silent has been the quintessential aspect of my client's case that has allowed for them to remain protected and thereby be able to obtain a positive outcome in their case. And so a very simple yet very important aspect of being able to combat the ICE enforcement that we're seeing in current times. Now, part of what CAI does also is we focus on common release for unaccompanied minors, which you can see on the screen. I'm not going to go into the mechanics of it, but I did want to point this out for anyone who's on the call on the webinar today that would like to learn more about where maybe you can start off if you do end up representing an unaccompanied minor, or you are currently representing an unaccompanied minor and you just would like to know a framework of where to work off of. This is a great one, especially because SIDGs and asylum tend to be the most common out of the 4 common legal reliefs for unaccompanied minors. And as we'll see shortly, they are very instrumental in keeping children safe. And so I share with you Letty's story. Names have been changed to protect identity. Letty's story essentially talks about a child who left their home country when they were underage to reunite with a sibling in the United States. It talks about the safety concerns that occurred in her home country and why she made the decision to come to the US. And in general, it ends with the acknowledgement that Letty not only pursued, but obtained special immigrant juvenile status. Now, for those that don't know, SIDGs is not a legal status that is provided to unaccompanied children or children in general. It is just, for lack of a better phrase, a stepping stone in order to be able to have a viable legal pathway. But it is helpful in and of itself because in having SIDGs, automatically when you are in immigration court proceedings or even in situations of ICE enforcement, there's no guarantee that the child will not end up detained, but at the very least, there's record that they have something that they're pursuing, on the record. And in my cases, at least in my experience in immigration court, you've had to battle, you've had to put the good fight, but there have been often times when immigration judges have terminated removal proceedings solely based on the fact that they have SIDGs in place. So that's also a great way to combat ICE enforcement. Again, it's not a guarantee, but it is a powerful tool to use. And outcomes like these and outcomes like mine, they aren't only possible with direct staff attorneys. It's also due to the pro bono work that our pro bono attorneys do. And our partners, through our mentorship and training and resources, they ensure that more children than not don't have to face the immigration process alone. Us as immigration practitioners, we're a small but mighty community, but sometimes, as we all know, we have a lot of cases that we need to work on. And so having pro bono help is very much essential to ensuring that even 1 or even 2 more clients than we could have helped are helped and are represented by a pro bono attorney. And so in line with our legal services, we also have what is called a psychosocial programs. And that includes our social services coordinators that provide trauma-informed support that complement our legal representation. And it's by connecting our clients and our caregivers with medical care, with mental health resources, among other support. And that allows for stability and for safety outside of the courtroom. And we consider it very essential to have this because it creates the well-being of the child, which is fundamental for effective legal advocacy. We can do as much as we can in the courtroom through paperwork, but if our client is not okay, then our advocacy can only go so far. And so in line with the psychosocial programs, we're able to ensure that our clients are at their best as we can so that they then can be open and receptive to the information and the education that we are providing them. Like, for instance, letting them know you have a right to remain silent, you have a right to an attorney. It is easier for them to remember that information.
And Christina, I do have to cut you off so that we can get to the next panelist.
No, that's okay.
But big question, if there is somebody here who wants to get involved as a pro bono kind of attorney, how do they do that?
Yeah, so it's very easy. You can talk to me. You can put my email in the chat. You can also, actually can skip over here, which is the next slide. You can also email our pro bono at supportkind.org, or you can fill out the interest form on Kind's website if you're interested. We definitely need pro bono attorneys. We have a great support system. We have samples and templates for you. We have our own pro bono attorney portal, which is dedicated. It's a website completely dedicated to pro bono attorneys. It includes up-to-date guidance. It includes samples and templates. It includes a breakdown and a step-by-step guide on how to prepare applications, ranging from state court matters to USCIS matters, and anything else that you can think of. It's curated with pro bono attorneys in mind.
Awesome. Thank you so much, Christina. That's amazing. And our last panelist today, we're really grateful that they are here today. Kel White from Acacia Justice is going to talk to us about habeas.
Great. I'm so excited. Thank you all for having me. And Adrienne for preparing us in the car between her trials. That was awesome. And a huge shout out to NorCal Resist because we've been working with them indirectly with the habeas program. I'm going to screen share and just let me know if you can see this.
We can see it now.
Awesome. Okay. So habeas, I'm going to briefly talk about it. We are so lucky to be in California right now because there are programs popping off to help people learn habeas law. If you're like me, I was an immigration attorney for 15 years doing removal defense work before I came to Acacia. And I did a little bit of habeas here and there, but not a whole lot. And so most of us had to step into it and get comfortable with this whole new world. So that's what I'm here to do in 5 minutes. But what's really cool about California and some of the other states I'm working in is that you can get on as be a panelist on the CJA as a court-appointed attorney for the federal bar and get paid to do habeas. So Eastern District of California, Southern District of California, Central District, those programs are popping off. And there's ways to get paid to do this, which is unusual because it's really, there's no court-appointed system within the immigration system, but there is the system in federal, which is great. And also there's EJA fees, which is wonderful. So we're going to move along. Habeas, let's just do a little refresher. Going back to law school, what is it? It's sort of the prove it or release mechanism. It's, the government's check basically on democracy at this point, saying to DHS, you got to prove why you are detaining this person. And it really can only be suspended if there's an Insurrection Act and in certain caveats with the Alien Enemies Act, which I am holding my breath on that one. So 28 USC 2241. And we're just going to talk a little bit about it, why it's so critical right now, because detention is really becoming, unfortunately, a when, not an if question at this stage. And so the reason why, I used to see clients who would be detained and stay in one detention center, which holistically, like if they're close to family, they're close to attorney, they're close to other resources, detention needs to be abolished. But it was, there were some mechanisms there. But now what we're seeing is people staying in one detention center being halved. There was a father from my daughter's school who was detained and sent to 7 different detention centers before he finally landed in Michigan. And so we were chasing him down. Transfers this new weapon against us in our community, makes it really hard to find your client. They're scared. It wears people out. But we have all these compounding factors. We have detention of all these 287G programs, Acacia's own data. There used to be less than 300, and now there's over 1,300. We got that bloated budget. We have these new warehouses that they're planning to detain, 80,000 people, holding 5,000 to 10,000 each one. And just to give you a gauge, most detention centers, the largest ones are 1,500 to about 2,500. You've got some big ones in California. But those are massive detention centers like I've never seen. And so this is real. The other major compounding factor is legal. This administration took away freedom and bond from immigrants by creating rules where people who entered without inspection are now no longer eligible for bond. And this has been battled out in the courts since July. And a lot of you all in LA and other parts of California saw this with the July 8th Lyons memo and the courthouse arrests. In that memo, ICE basically said that they themselves just have the power to, grant parole authority to folks who came in EWE. And EWE means like walking across the border, just so we're all on the same page. Not coming in maybe at the airport or coming on a B1, B2 visitor visa. That was immediately challenged by human rights groups. You see University of California and a number of groups here. Then September, you see the Board of Immigration Appeals saying the same thing that ICE just said, which usually you don't see in my 15 years of practice. Another agency is saying the same thing that DHS is saying. And then we saw the Baldonado Bautista case. We won. I'm not class counsel, but as a collective group, all of us gathered here today, all 300 of us, we won in the sense of we got a good order for partial summary judgment, which was wonderful. But then you saw a lot of immigration judges ignoring it and saying they still do not have authority to grant bond to people who entered without inspection, which is tens of thousands of people in this country. And so they went back and had that to federal court and had that order reclarified, which also I've not seen never have to have happen. And then you see on January this year, the chief immigration judge sent out an email saying to ignore a federal court order, which is unprecedented. And so now what we're going to see play out is going to be a bunch of circuit splits. California, Ninth Circuit, that was actually, sorry, Oregon or Washington State. You all just heard yours yesterday under the Rodriguez-Vasquez case, just had oral arguments. So we'll see what happens there. And so I want to really set this up as, because this is a question of when, not if. Acacia's focusing a lot of resources and our overall structures. We've funded a lot of removal defense programs for the last 10, 20 years. And we're investing right now in habeas programs, and we're investing in contingency planning. And so we worked with Human Rights First to develop this app that's technologically safe, so that if people are going to get detained, they can notify instantly their lawyer, child care pickup, legal aid, their dog or cat sitter, if they need support. I've downloaded it on my phone and played around with it. It's pretty user-friendly. It's on many languages. And it's something I would really recommend that you share with your clients if you're an immigration attorney as a backup measure. And I just want to talk about the on-ramps to habeas, because this is pretty critical. It's really a matrix. If you're an immigration attorney like me, there's 94 federal courts, which is daunting. And so each one requires that you get admitted to one. And so you got to figure out where are clients in your area getting detained, where are they getting sent to, and where to develop relationships there. And hopefully, Acacia's done a lot of the groundwork for you and some of these orgs here. I mean, the good news is that we're winning, hands down. This is the silver lining of this horrible administration, is that we're winning in federal court. Over 94 courts, and the majority of them are in our favor. And the way to get into them, if you're an immigration attorney and this is new, is you can pro hoc vice in, which is for this occasion, for this fight. You're going to get in there temporarily just for this person's case, or you get admitted to the federal court, or you're going to refer out. And this can be, and what we've done for you is we've created a matrix of all the pro hoc vice rules by state and district court, so you know how, where it's going to be easier to get in, where it might be a little bit harder, and what kind of documentation you might need to get in a row, your ducks in a row before you start applying, and maybe before you start taking on some removal defense cases.
So I'm sorry to interrupt you, but someone would like the link to the website. If you can put it in the chat, I can put it in the Q&A.
Yeah, I can definitely do that. If you can't scan the QR code, it's also on our website. I'll give you, yes, it's also linked later, and it's on our website. I'll do that. Thanks for that. So if you're not going to pro hoc vice, which is usually temporarily, most states have limits. Like Mississippi, you can only appear 5 times. They've got they got a big detention center down there. So if you know you've regularly got clients going to Mississippi, then you might want to get admitted to there or get a good relationship down there. But otherwise, people are stepping into federal court. The issue with federal court is a lot of them do require that you actually have state bar admission. And if you're already a California attorney, thank you, CLA, then you can easily get into California, because California requires state bar admission. You can't just waive in. I've just waived into another state recently. The process getting a full bar application together. It's that whole shebang. Whereas if you're just applying for the federal portion, it's a little bit easier. And so you need to like learn all these rules. What we've done in the meantime is if you need if you need a referral in a state, or if you need somebody who might be admitted who you need to support you to Pro Hoc VGN, we've created this chart. We have 48 states, including Puerto Rico and District of Columbia. So we've almost got all the states mapped out where you've got a contact in each state there. So these are links, and I can drop these links in later, or you can scan the QR code. And that way you can network with where folks are going. So other resources, we have our practitioner hub on this PowerPoint. These are all links to templates, trackers, and trainings. All these trainings that I linked here are free. I try to gather all the free resources in the nation to share with you. And so there's our practitioner hub. You can link in there. If you want to see what's going on in your own region, Habeas Dockets is a great resource where you can pull up your local federal district court, and you can see how many cases are filed. You can see what type of cases. You can use easy search terms. I'm on their board, and we're working on tags, especially in Southern California. We're looking at like how many fathers have been detained. What was the situation like along, the qualitative information around the rest, so we can start to make these arguments in a more public space about what's going on and how our people are being harmed. And then there's the starter kit. And I will drop this link in the bottom. Mentoring programs. If you're looking to start taking on habeas cases, EDCal, Nichols, and Nardi, and Rise Hub, they're a great contact. The Federal Defenders has got a program as well, so their emails are there. We've got a habeas bridge program in Southern and Central District of California, and can link you to folks there. Northern District of California, you all have CCIJ. And then nationally, you can, we have a National Immigrant Legal Responders Alliance where we've contracted with Amica Center, my old organization, and HRF to mentor people in different states around the nation. So if you've got a client who might have been picked up here in California, but sent too quickly to Texas before you could file that TRO to halt the transfer, with that habeas petition, then there might be a possibility to find either use that resource I shared earlier to find a connection in Texas of somebody who could take that case, or get mentored through our program.
Thank you so much.
Yeah. Okay, I'll stop. Thank you.
Thank you so much, Cal. That was amazing and really amazing work that you're doing. With the 7 minutes left that we have, I'm going to kick it over to Maria Dominguez, who's going to sort of prompt any questions that she's set up.
Well, thank you everyone for the very lively chat. We had over 300 attendees and I believe 500 registered. So that's definitely a testament to the appetite for more information at this time. I believe all of the questions are in the process of being answered. Someone asked if there's cooperating participating attorneys in San Diego, and I do believe they're the Southern District of California is listed. So I just provided the link. And let's see, there's some other questions about interest in connecting and looking into ICE-free zones and how federal funding may impact the community for signing such ordinance.
There was another one too, because we had to move on earlier. There was a question I think David had for Miss Martine. I don't know if you remember that question.
Yeah, maybe we can invite and I can pin everyone so we could have more of a group chat here in the last minutes. David, I believe you had a question about a California Penal Code.
Oh, that's what we were ending with, was just there is a penal code provision that says you have to inform criminal defendants of the immigration consequences of their plea before it's entered. You have to have a record of it. And actually, even way back in the 80s, I was able to vacate or expunge convictions based on pleas that were entered without doing that. While I'm looking, there was another question too I couldn't find, but I had a lot of kind of depressing questions, but I said answer with something more uplifting. a little note that of ancient law, that in the Torah, which is the 5 books of Moses in the Old Testament, the most often repeated command from God is to do justice, be kind, do not oppress the alien. God repeats this. I counted 25. The rabbi I learned this from counted 34. That rabbi bar mitzvahed my son. He also bar mitzvahed Stephen Miller, um, who apparently was not paying attention in Hebrew school.
And David, just wanted to flag that the penal code to get a conviction overturned for failure to give that standard admonition is 1473.7. So if you're looking to do that in a criminal basis, and also for anybody who's practicing criminal law on both sides, there's the United States Supreme Court case Padilla, which states that anytime you're doing any negotiations, that has to be taken into account. So for all us criminal practitioners, now more than ever, on both sides, right, on both sides of that aisle, like that's just as it's more important now than ever to keep that in mind as we're practicing.
Yeah, I can't find the other question. I'm sorry that maybe I'll find it later. But in the meantime, maybe I can ask a general thing. One of my depressing questions is, what about people? I think you mentioned people being moved from one place to another. Um, how can people help in those situations where someone is detained in a center that is far away from other resources? There's deafening silence.
I mean, I think that's part of the weapons that's being used against us is that people get removed to the remote areas. I think part of that resource we created at Acacia was to address that, is that mapping out, 48 states we have mapped out with connections, at least, of attorneys who are on the ground in those states who can file habeas petitions. So that might be one starting place. Acacia has also mapped out legal aid organizations that are visiting detention centers in remote areas as well. And I can't share that link now. I'm not gonna find it in time for you all, but I can send it to Adrianette maybe afterwards and she can share it out.
Another question that came up: if an employer discovers that it only has a portion of an employee's I-9 on file, what should the employer do? Anyone with employment expertise, or maybe could.
Well, we deal with that sometimes because I represent unions and labor, and they do. That's part of the 1986 law, was they're required to maintain those forms. But what I've seen is what I call the I'm shocked defense, that employers, when 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 some of their employees complain, they try to form a union, they demand their wages. All of a sudden, just like the inspector in Casablanca, I'm shocked. I'm shocked to find gambling, illegal aliens here. And then his assistant comes up and gives him oh, here's your winnings, sir. So employers do have that obligation. And if they find that something's missing, I guess they have the obligation to fix this, but I'm very dubious of that because it's usually just an excuse for getting retribution against the workers.
And I think I can provide a link to, I think the National Employment Law Project may have some resources on this, so happy to include that in our post call. And I think the last question that I flagged for everyone is, do you have any advice for transit agencies and what to do if the feds try to board your vehicles to look for someone? I do want to make a remark that we're planning to do a part 2 since there's just so many different topics to cover. So I love these questions that are more about our local questions. So definitely going to save the Q&A before this closes out. And we are at time at 7. So if anyone could give a virtual round of applause to all of our speakers and panelists and our committee members here. Adrianette, I will turn it over to you for last words.
So much. We had the highest number of people register for this super informative, relevant, powerful program. I want to thank everyone for all of their time. I want to thank our panelists, our attendees, CLA, Brianna, everyone. This has just been better than I can imagine, and I just appreciate everyone and looking forward to the next one. Have a wonderful evening, and thank you again.
Thank you.